All
Mhm.
right. I'm going to get rid of all of you all because it takes up too much room. All right. The overall layout of the presentation will be to go over essentially how the Office of Social Security and Disability makes determinations around disability claims. It will go over the process that they do, um, where some of the hangups can be in terms of those record requests coming in. And then at the end, there's a little section on responding to lawyers. Honestly, the presentation really focused mostly on disability requests. But what I also did was once I finished the presentation, I took the presentation into consideration while trying to answer as many questions as you all submitted. And then this morning, actually at 7:30, I had an hour-long talk with the Office of Social Security and Disability on disability determination services and tried to answer as many of those questions as possible. And they were very nice, very kind. You'll see at the end that some of the answers that they gave actually contradicted some things on their website, which I tried to address. But I will say ultimately, you probably want to go off of what's on the Social Security website, although the answers were very interesting. So let's dive into this. So the goal of the presentation: better understand the limits of confidentiality and HIPAA as they pertain to disability requests, learn how to best talk to our clients about confidentiality. And I would love for, if we have the time at the end, to talk about specific scenarios that you all might have. And then explore various ways of talking to lawyers when they release records. So quickly, just in terms of responding to the survey, nobody's identified, but there's just some metrics that you can see. But in terms of levels of comfort, it was really good. Nobody was at the very bottom, being like really afraid and worried, but nobody was at the top being like, I'm an expert at this. So I think it's a good time for this presentation. Um, in terms of responding to disability requests, awesome. Nobody said ignore the request. We will get to why we can't do that. Um, what was also interesting is the purple response there: send the records outright. Um, as we will get to later, in terms of actually going over what's called the SSA 827, I believe is the form that's filled out to Social Security. That form actually gives you, the provider, permission to send all records without a release of information or any conversation with the client. So even though nobody selected the purple answer, send the records outright, you actually have the right to do that. So none of these were actually the wrong answer. We'll actually get to later on that you can't ignore the request, but there's ways to get around it if you don't feel comfortable doing so, or you think you're acting in the client's best interest. So again, none of these are wrong, but I think that's why this conversation is very complicated. There are many different ways to go about releasing records. What I did find interesting is that I asked the question around, how did your school teach you, or your education teach you, how to respond to disability requests? And it was very interesting. There wasn't like one response that was the same across everybody. And I think for me, it shows that schools don't really teach early career psychologists that well on legal matters. I mean, even me, I don't remember a single class I took on legality. Obviously, you have classes on ethics, and we had presenters who were lawyers who talked about specific concerns. But I didn't have a seminar on the legality of the practice. And so I thought maybe my school was the fluke, and I was like, I got a really crap education in that regard. But then the responses actually really helped me to feel really good that actually there wasn't a lot of education in this domain. So quickly, before we start talking about it, I thought it was important to list definitions. And you'll see that I try to incorporate definitions from different places. So first place I consulted was the trust. They are the agency that we have our liability insurance through. So according to them, disability for any occupation is the inability to perform the duties of the occupation you are suited for by age, education, or training due to medically determinable physical or mental impairment. And it's really interesting that they talk about that, because when we get to talking about disability later, how Social Security defines it, it's actually kind of difficult to get disability on the claims of mental health. Physical is really easy. They say, oh, you had an accidental dismemberment, you lost an arm, and you work in construction. It's almost like a slam dunk case. But even if we have time at the end, I'll talk about times where I've had at least 3 clients who tried to get disability on mental health, and only one was able to get it successfully, and the other 2 just continued to appeal after appeal. So even though these are the definitions of the trust, they do differ slightly from Social Security. And then according to the trust, disability in Social Security is the inability to engage in any substantial work activity defined by a dollar amount, no less than $500 a month. Because with SSDI, if you make over a certain amount, I believe it's 12,000. I actually didn't confirm that anywhere in my research, but once you make over a certain amount, you no longer qualify for disability. But then according to the Office of Social Security, definition of disability is different than other programs. Social Security only pays for total disability. So sometimes when we see claims for short-term or partial disability, as we'll talk about later, that is traditionally not the Office of SSDI, although there are some differentiations state to state. So yeah, no payments, no benefits are payable for partial disability or short-term disability through the Office of Social Security. And they consider someone having a qualifying disability if they meet the following rules. You cannot do work and engage in substantial gainful activity because of your medical condition. And they define substantial gainful activity as any side job or hustle that makes more than that minimum amount that I talked about before. So I had a client 6 years ago who lost disability because they claimed Venmo payments on their taxes, and they had a side job where they made jewelry, and they made, I think, like $800 more than the minimum. So even though they only made like $20,800, they lost their Social Security because of that gainful activity clause. And you cannot do work you did previously or just other work because of your medical condition. So they ask that you remove yourself entirely from that profession and do something else on the side. And your condition has lasted or is expected to at least for 1 year or to result in death if you continue to work. So you'll see much stricter definitions in comparison to the trust. Short-term disability, I don't talk about that too much in this presentation, but really short-term plans are unique to the job or the insurance the client has. Some states actually have temporary employment clauses and short-term disability, like California. Maine's not one of them, but a lot of these states, I think there's 5 of them, that pays into FICA, and there's a program like that. In Maine, and it's really state employees or people who have supplementary coverage. So I've been looking into this for a while, and I need to pull the trigger on it eventually, but you can actually get disability, temporary disability income protection through the trust as a psychologist. And it's always been on my to-do list to sign up for it, but I never seem to get around to it. So that's an example of if one day I was injured or I had a mental health issue, I needed to take a month off of work, I would have to have that paid separately. That's not done through Social Security office. And it's traditionally 2/3 of your salary, although you can pay a higher premium to get more income. You can just never make more on Social Security than you could in your job. So I can't pay to make $1 million a month in disability because then I would pay for that and then probably try to find a way to game the system. Not me personally, other people. I found this really interesting. This is the Maine disability statistics through the CDC, and these are from 2020, I believe. That over 340,000 adults in Maine have a disability, equal to 1 in 3 adults. Now, this doesn't mean that 1 in 3 people are on disability or receiving disability payments. It means 1 in 3 have a registered disability. So this might mean that they get accommodations at work, or that they had a disability in the past but returned to work. But according to what I saw, this puts us in one of the higher states. I think the nationwide average is around 20 to 25. So for us to be at 33% is quite high. And then percentage of adults in Maine with select functional disability types. You'll see here, they don't really include mental health in their statistics of the CDC. I believe, and I tried to find clarity on this, and I even asked SSDI this morning, do we fall under cognition? And they said, yeah, kind of. Like if you have a difficult time making decisions because you're depressed, then it typically falls into condition. They also said that mental health can fall under independent living, particularly people who have low functioning autism or a neurological condition that would impact their ability to be independent. And then potentially self-care. I asked what falls under self-care, and there wasn't really a list like the other ones. Like mobility, they were very easy. It was very easy to say, broken limb, dismemberment. But self-care, it's the lowest category, so I imagine it's also one of the hardest to get disability for. And then disability health costs in Maine. I was really intrigued by this, not the fact that we spend 37% of the state's healthcare funding on disability, but actually how low the disability payments are. I mean, $18,000 a year. Can you imagine living in the greater Portland area trying to live on your own on 18,000 when I think a studio apartment goes for like $1,000 a month? So it's relatively low, but when I compared it to the national standards, it wasn't significantly. Like even places like New York and DC, Miami that have much higher cost of livings, they average around 25, but it never goes above 26 because that's poverty at the federal level. So it's not a ton of money, and that's the average. I've had other clients who get less than that. And then this is probably my least reputable source, but it was the only place I could find the data, is disabilitysecrets.com. It sounds like a terrible website, but it had a lot of really cool information on it. And it's they sort of build a website around how do you get data as someone applying for disability when it's not easy to find on government websites. So even though it's like very cheesily named, I thought it was really interesting that we are right around national averages, other than hearing approval, which is at 56%, which is actually good and higher for us, and the hearing wait time, about 10 months. And it usually takes about a month to make a decision after the initial hearing. And that contrasts with some other information I asked from the Office of Disability Determination. But nationwide, average being 18. Another good example of a client of mine who had a physical disability and met the criteria for PTSD had to appeal the process 3 times. And so by the time she finally got to getting disability, I had worked with her for 2 years and she had been in the process for 3. So by the 5th year, she finally was able to qualify for disability. And we'll talk about later on, it really is dependent state to state, but usually the Office of Social Security will only back pay at time of application of the initial appeal. So if I get denied and then I appeal it, the clock starts then. But if they deny that first appeal and I re-appeal, then the clock restarts. So that doesn't go back to the first appeal. It just goes back to the most recent appeal. So for someone like that, it means really 3 to 4 years of lost income. Granted, they were trying to work and make income on the side. But again, that's state to state. In Virginia, it was date of last appeal. So how does the Office of Disability Determination work? Step 1, eligibility of coverage. So first, the office determines whether or not your job has ever paid into Social Security or unemployment programs. For example, money that comes out of FICA payments. This determines whether or not the client would get Social Security disability insurance or supplemental security income. I would guess, based on our practice and the clientele who come to therapy, mostly because we don't take main cares and Medicaid, 95% of our clients are coming in applying for SSDI because the payments are higher and they get better benefits. That's the program you pay into. The supplemental security income is for people who have never held a job or have never paid into Social Security. And the payment is quite low. It's like, I think what I saw on the Social Security website can be anywhere from $150 to $200 a month at minimum, $400 a month really at maximum. And like I said before, there are also states that have supplementability dispayments paid through FICA, but Maine's not one of them. But I did write for those who have e-passports. Those states are California, Hawaii, New York, New Jersey, Rhode Island, and the Territory of Puerto Rico. So these are locations where you might not be hearing from the Office of Social Security. You might be hearing from the state level state level government asking if the client qualifies for the state short-term disability. There's other ways of qualifying for disability payments, but the presentation will focus largely on the clients themselves. This is where I really got into the weeds. I ended up deleting like 12 slides because it was like too much, and I don't think we'll run into them very often. But there's situations where if your child under the age of 18 is disabled, you can ask for disability payments through your Social Security payments. Guardians and spouses can file for disability on behalf of the person that they're married to or have legal power over. Same with incapacitated adults. So there's a lot of other ways to get disability payments. I hadn't run into any of those situations. I'd be curious at the end if any of you have, but I don't think that they're very common. The one thing I wrote, though, is really important is the age of 22, according to the Office of Social Security. If a client was diagnosed with a disability under the age of 22, under the age of 22, then they can file for disability using their parents' Social Security payments. So I tried to ask this question this morning, didn't get a great answer, but the sort of understanding that I had was that if you had a child who was diagnosed with disability at 8 and got disability and then left disability and then was going to reapply at 35, but they had the same disability, let's say, again, low functioning autism. My understanding of the Office of Social Security is that because that client received disability payments under the age of 22 and that had been billed under the parent's Social Security, they could probably rebill under the parent's Social Security. So this is really to help those people who have a registered disability from such a young age that they probably can never really have gainful employment. And I get it. I think it makes sense. You know, say for 10 years the child tries to go to college or tries to work independently, can't do it, and they have to move back in at home. They have to have some way to take care of them. So once you have met eligibility for coverage, that steps into qualifying condition. And this is where we would get involved as therapists. The SSDI investigators use a form called SSA827. You can look at it if you want. It's really boring, but it basically just has a bunch of check boxes. Do you meet any of these criteria? And once this form is filled out, it is used as the sort of base tool for gathering medical information. What I found really interesting and early in my career, I used this argument, you know, because of HIPAA, I don't feel comfortable or safe sending records. And what I read through the Social Security office and got verified this morning is that you can't use that argument. HIPAA does not apply to disability claims because SSA 827 was written in mind that it could circumvent Privacy and Portability Act laws. And it has been approved by the federal government to do so. So it's something to take into consideration that HIPAA is a federal law. So if the federal government creates a form and says that this is HIPAA compliant, then we have to listen to that because we can't disagree with the very organization that created HIPAA in the first place. And so this is actually a statement from their website. The SSA 827 was developed in consultation with the Department of Health and Human Services component responsible for the HIPAA privacy rule with extensive input from the American Health Information Management Association. Blah, 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 blah. It was approved by the Office of Management and Budget with the concurrence of Health and Human Services. So according to Social Security, HIPAA does not apply to the sending of medical records if a disability request comes through. With that being said, we'll talk later on that there are other reasons to not send records. So what I referenced before, that you can just send the records outright, this gives you permission to do that. So if you ever did get a disability request and you just sent the records off right away, you're not doing anything wrong. Because the SSA 827 form also includes a release of information. I think it's still in best practice to get that separate release of information on our side anyway. And it's a good idea to sit down and go over the client what's in the record before you send it off. But according to the federal government and the Office of Social Security, this form is sufficient to cover all legal bases. So I made that mistake early in my career and had a lawyer tell me that I was making a mistake. Going back to qualifying condition, there is a fact sheet, which is this link at the bottom, and I will send this PowerPoint out to anybody who wants to keep it for the record. It's actually a really helpful fact sheet. But basically they're saying is like information from you as a mental health professional is vitally important. They really want you to respond, and that's why they created the form that legally permits you to make the necessary disclosures of information consistent with applicable laws. And then they list all the laws that this form is compliant with. With that being said, this does not mean that the provider is required by law to do so, just that the forms and information requests are legally permitted. This does not act as a subpoena, nor can it compel the release of records. This is why the Office of Social Security also includes an ROI that is signed by the client. So even though they're saying you have permission to do so, if you also don't respond, you're not going to be sued. At least by the Office of Social Security. You may be sued in civil court by the client if they're thinking that you are acting against their best interest. But from what I understand, I had this verified by the person I talked to this morning, it is not a compelling argument. It is not a subpoena. You are not forced to send the records. I would say best practices, though, would be that you adhere to the form and respond. So step 3 is approval or rejection. client will either be approved for disability based on the information the office received, or they will reject the claim. If the initial claim is not approved, like I talked about with the previous client before, they go through a reconsideration approval followed by a hearing approval. If any of you have had clients who've gone through this before, it's a very long process. I mean, if it takes anywhere from 10 to 12 months just for the first claim to be approved, from what I have seen, it usually takes, you would think it takes shorter, the reappeals process, because they have all the paperwork and necessary forms. But what actually happens is that the appeal is viewed as a lower priority compared to people who are on their first application process. So the reappeals almost take the exact same amount of time. And the client I was talking about before, who went through 3 appeals, is 5 years for the 3 appeals. So it's a very lengthy process, and you also have to get approved through the reconsideration process. So if you are not approved, you don't get the hearing approved, and as such, you have to either hire a lawyer and try to sue the state into reapproving, or at least considering. Or what I've seen happen with 2 cases in the past, they change states. They can go to a completely different state or apply through disability through a different disability office. And I had a client in Virginia who actually was approved for disability having left Illinois, where they were not able to get disability. Because even though it's all the same system, it's all under Social Security, the disability determination offices are state dependent. So if you switch states, you get an entirely different appeals process. You get entirely different staff that you can work with. So it's not a perfect system by far. And I think back before the previous states. So yeah, the initial claim approval, 34%, nationwide being 35%. So that means 65% of people have to go through an appeal process. So responding to records requests, SSDI and the federal government has determined that the form meets the HIPAA requirement for minimum necessary standard, which is the part under HIPAA that states that you have to have the minimum necessary standard to protect that client's confidentiality. So an ROI is in place, which it is. It's a part of the form. HIPAA cannot be used to justify not releasing a record. So does that mean you have to send the whole record? According to Disability Determination Services and the SSDI, the short answer is no. You don't have to send the whole record. So here are the caveats. To make a determination for disability, records are needed for at least 12 months prior to the request. So if you've been working with someone for 4 years and they request a record, it should have a timeline on it. It should say for the last 12 months. If it doesn't, you have the right to only send the last 12 months worth of notes. Everywhere I saw on Social Security, when I asked Disability Determination Services this morning, a couple other websites I looked at, they all consistently said 12 months, which is good for records releases. It's tougher for clients who have had longer and persistent disabilities. You can't use evidence prior to 12 months ago. So if you had a disability, let's say for 5 years, they really only want to look at the last year. And I guess even though it doesn't seem helpful to the client, it makes sense to me. They're trying to determine, can you work now? Not, did you get an injury 5 years ago that you are now saying can't allow you to work now? We need to see proof in the last 12 months that you could not work. So that's why they're only looking at the last 12. So it's important to take that into consideration, because sometimes you'll get a full release saying send all notes. They don't really care about all the notes. They just care about the last 12 months. Psychotherapy and clinical notes are also protected. And I took this quote directly from the Social Security office. Social Security recognizes the sensitivity and extra legal protections that concern psychotherapy notes, also called process or session notes, and does not need the notes. And they go on to define psychotherapy notes. Basically any part of the conversation of that therapy of what you actually covered. But it says psychotherapy notes at the bottom excludes medication prescription and monitoring, counseling session start and stop times, the modalities and frequencies of treatment furnished, results of clinical tests, and any summary of the following: diagnosis, functional status, yada, yada. So if you actually take our note and then you get rid of the actual subject section of what you talk about, you could redact that if you wanted. Pretty much every other part of our note, I think, covers everything that they would be looking for. What we'll get to later on is that a lot of people actually don't send the full record. They send summaries, which you're also allowed to do. I said I was going to hold off on questions, but anybody have questions on this part? None. Excellent. So this means you have several options of responding to a request for disability. One, you can send the whole record. I would recommend consulting with the client. This happened last year with a client who just signed. Most clients just sign everything. They don't actually read what they're signing. I mean, how many of you have Apple phones and haven't read the contract that comes out with every new update? That's 20 pages long, size 4 font, single space. It's overwhelming. So a lot of our clients sign things without knowing what they're signing. And so I had a client who was applying for disability, had a really great case for it, was in a really bad car accident, and then just signed all their psychotherapy notes over. And I said, hey, there's like a lot in these notes that you talked about that are not relevant to your disability claims process. And you check the box for your entire record. So let's go over it. And I printed it out in session and went over note by note things that I highlighted in advance. And I charged her for my time. And I let her know that that was going to happen because it takes me time to print things out and highlight everything, and showed her the 20 some odd sessions in there that were about her marriage, that were about her anger towards her boss, the job that she's trying to get disability from. And anger does not mean you can't get disability, but I don't want anything to hurt her process of getting disability. So once we went over all that, I said, are you sure that you want this sent? And she said, hell no. And so we redacted the ROI, or not redacted, rescinded the ROI through Social Security. I reached out to them and let them know they will sign an updated ROI that I will fax to them. And it basically was the exact same ROI, except for entire medical record was not checked off. It was summary and termination of intake and termination summary, since it was a client that I had ended with a couple months prior. And that was fine. They were completely content with it. So yes, you can send the whole record. I would highly recommend you talk to the client about what's in it.
If the client consents to sending the whole record like that, though, you don't necessarily have to. Like, would you have to get a new ROI where you take that back? Or would you say, like, I know technically on this ROI you've consented to that, but I am actually choosing based on our discussion to do a summary instead?
I have always chosen to redact the former one and create a new one, because this has only happened once before, but I read a couple of instances online through an actual subreddit for psychologists who've gone through this process, that what happens with Social Security or any other federal office, they say, well, we don't care. We have the ROI on file. So you have this conversation behind closed doors that they have approved and not send the whole record. We have none of that in writing. So send the whole record.
Okay.
And it's not that far to redact it. It's not that hard to redact it. You just have to send an email with a form stating that it's been redacted. I sent a Word document with 2 sentences. So I met with so-and-so on this date. They have chosen to redact the ROA signed on this date by your agency. And then they signed it with a wet signature. And then I attached the new ROI. So maybe that's like being a little overly paranoid, but the first thing I learned in grad school, and one of those times when the lawyer came to talk to us, is that if you don't have it in writing, it never happened. So I tend to document everything. I put all emails into clients' records because I don't want any communication to not be documented. So 2, you can send the record with the psychotherapy notes section redacted. I think that's arguably the hardest of the options, because you have to, unless you have the software to do it, you have to highlight all the sections, black them out, save it as a PDF so it can't be edited, or you have to print them out and go through it line by line. You have the option to do that. I think it's the least effective of these options. And then number 3 is the one I've done more often. And I think it's the best outcome because 80% of the time it's sufficient. So write up a quick 1-page, 2-page report. And then if they say they need more, respond to that. But the Office of Social Security says that you can send a special report that details the critical, current, and longitudinal aspects of your patient's treatment and their functional status as defined by that previous slide. So how many sessions did you have? How long did you meet them? What were their diagnoses? Did you do any assessments? And most of the time, you could actually probably just send the intake. I mean, the intake covers pretty much all of this with a section added at the end saying, since this, here have been any updates to their care and how many sessions I had with them after this point. So you can absolutely send a special report, and that's their language. This is copied and pasted from their website. All right, checking the time. So important factors to note, you are not acting as an evaluator. This is on the Social Security website, but this was also on a couple other websites I looked at. Try to avoid writing reports that state that you believe the person qualifies for their disability. they will have an independent assessor. The Office of Social Security always has a psychologist or a psychiatrist or a mental health worker interview the person applying for disability. That person's job is to assess. Your job is to provide history. So if you can provide the history, it helps that person do their job much better. It's pretty rare that that person reaches out to you. If they do, that contact is not included in the ROI, so you'd have to get a separate release. And yeah, basically it just acts as supplemental evidence. If you outright refuse to send the records, then the determination will be made solely by this evaluator, who will make the entire decision about disability off of one clinical interview. If they don't have the information, I would guess that most of these interviews are, they don't go well. They're trying to prove a disability without any medical documentation, which is why I think not responding at all probably does your client the most disservice. But again, you have the right to not respond. But it does leave you open to legal action if the client has signed an ROI and you are acting against their best wishes. Record ownership. So quick note on ownership. Medical records belong to you as the provider. It is your intellectual property. So while it is the job of the psychologist to maintain records, protect them under HIPAA, federal and state law generally entitles patients to obtain copies of their records. And this is probably my least favorite part about doing presentations going into law. If you ever read state or federal law, it's the most boring stuff on the planet. So I tried to summarize a 22-page subsection of this law in 3 points. Clients can see and get a copy of the record. This must be done within 30 days unless an arrangement in writing is obtained extending the timeline. So if a client releases their records not responding, while at the federal level you're not going to get in trouble with Social Security, you may get in trouble with the state, because that is Maine state law. You have to respond to release within 30 days. Now, that doesn't mean that you have to send the record within 30 days. You have to respond and at least make an argument in writing as to why you do not feel comfortable sending it. If the client responds saying, I don't care, I want my records anyway, under state law, they have the legal right to their records. Healthcare providers are allowed to charge a fee for copying records, and you can even charge for postage. I thought that was really interesting that they included that very specifically as own subsection called postage reconciliation. You have the right to charge for postage. But it says not just the charge for fee and copying records, but also the time it takes to compile them. And if you're going to redact records, you can charge for that time as well. This last one was really interesting. Clients can request that information be added to their medical record to make it complete or correct inaccuracies after review. So in that instance where my client came in and we went over all the records, they do have the right to say, oh, that's not what I said in that session, or that's not what I believe happened. Now, the provider can deny this request. And I would say 90% of the time, if a client's saying, oh, that's not what I said in session, I'm going to believe my notes because I wrote them 6 months ago. So if they want to change any part of the record, you as the provider could either correct those inaccuracies. And this actually use an example where I have done this. I got someone's surname wrong. When they got married, I wrote their original maiden name and I got that wrong. So I wrote an addendum saying I was incorrect in my record keeping. But more often than not, if someone's like, oh, I didn't say that to that person on that date, they have the right to add an ability or their own short statement to the medical record, but it comes from them and it gets stapled in the back or included in the PDF because we don't staple things anymore. All right. And so when I was done with all this, I wanted to reach out to SSDI and ask some specific questions based off of what I got in survey results. There were a lot of very specific questions in survey results that I think would be better used in talking amongst the leadership at PSM around policies, protocol changes, paperwork. So I'm not going to really address that. I mostly wanted to talk about the big themes that came up in the survey. So, are there consequences for not responding to a disability request? And these are direct quotes. I asked her if I could quote her, and she said yes. There are no legal consequences, but the refusal does hold up the process and typically upsets the client applying. The process already takes a long time, so waiting months for no response usually delays the process unnecessarily. If there is no response to either initial request or the follow-up request, then an examiner hired by the state makes a determination after clinical interview. So, again, are there consequences from Social Security? No. They're required to wait a month from you, and then if they don't hear from you, they send a follow-up request, and then they have to wait another 30 days. Traditionally, after that, you don't hear back. but that also inherently extends the process 2 months if you're not responding. So it's almost better to just respond and say, I'm actually not going to send the records unless I have permission from my client and I have a meeting scheduled in 2 weeks, than to not respond at all and leave them in the dark. But are there consequences? According to Social Security, no. Do you prefer whole records, redacted notes, or summary letters? And this is one of the things that they contradicted, their documentation. It says on their website, we protect psychotherapy notes. And she was quite emphatic, whole records. Psychotherapy notes are protected, but receiving the whole record makes determination much easier. The client has a right to ask for sections of their note to be omitted, though, like history of sexual violence from their past that's not related to their claim. We typically do this with them before submitting the request, but it can be done with the provider before sending the record. So they sit down with the client after the SSA form is filled out and they go over every aspect of it. And there's a part of the form that asks, are there any parts of your history that are not relevant to your disability that you do not want the federal government to be aware of? And I mean, obviously, you see the irony of this, that they then have to tell the disability office what they don't want them to know. So they could like write childhood history, and they're encouraged to keep it as amorphous as possible. And then they can send an updated release or SSA form to the provider stating include records except for records that pertain to these factors. I can tell you, having gotten disability requests, I've never seen that in my career. Maybe other people have, which is why I think it's more important that you as the provider sit down with them, go over everything, and do this before sending the record. So, but according to disability determination in Maine, they prefer the whole record. How are records stored and kept after sending them to SSDI? Have there been any legal consequences for lost records that involve the provider? We have our own internal server that stores all medical records. The server is fully HIPAA compliant. We have, to my knowledge, never lost anyone's record. I'm also not aware of any litigation that involves providers or lost or misused records. And I think that's something that therapists are generally very worried about. Once I send the records, like what happens to them? Do they just disappear? I asked, do they shred them or destroy them at the end of the disability approves process? She said no. So I said, what do you do with them? And she said, we hold on to them for 7 years. And I got into like a little bit of a debate with her because the 7-year mark is for us as providers to hold on to a record. There's nothing in the law that states that a government office should hold on to records for 7 years. So I was like, why are you holding on to them for that long? Unfortunately, she didn't have an answer. So that's just it. She was the spokesperson. She gave me the information. I would love more clarity for that. But they do typically hold on to records longer. I did feel somewhat comfortable, though, that they have their own server protected behind firewalls. And she's like, to date, I'm never had heard of any like misused or lost records. What if you believe that the client is cognitively or intellectually impaired to the extent that they do not understand informed consent regarding the ROIs? She said, I would send a letter to SSDI stating this without sending the records, without further clarity from our office. And I love this part. She said, honestly, getting a letter stating that they're too impaired to understand the forms further supports their claims and is sometimes sufficient. So just you saying they don't understand what they're signing is usually sufficient enough for them to get disability without having to send the entire record. And so the last part, good. I was hoping to do this in 45 minutes. Just quickly in terms of responding to lawyers. Two types of responses you get from them: subpoena, duty to appear in court and testify. Subpoenas duces tecum, duty to provide documentation at the court's request. I've gotten 6 subpoenas in the last 10 years, 5 of which were for disability or state claims. They've always been subpoenas. I've never seen a subpoenas duces tecum. I don't know if that's just because they're not common or it's just been my luck. But it's always been they would want me to testify. And to date, I never have. But one does not simply ignore a subpoena. Please don't ignore a subpoena. This is a court-ordered document stating you have to respond. So don't ignore it. So how do you respond? When receiving a subpoena, the psychologist does indeed need to respond to the request. This does not mean that confidential information needs to be disclosed. According to the APA, providers need to ensure that the subpoena is valid and that the conditions for disclosing confidential information are met, such as with the client's consent, protective order, or other legal mandate. If a psychologist determines that the subpoena would violate a client's right to confidentiality due to any of the next following statement: good clinical practice, ethical standards, professional licensing laws, and other applicable statutes and legal precedents, then the court order may be requested. Then a court order may be requested. And we'll get into that next. Now, this is directly from the APA. So a court order would then be requested by the lawyer or by you as the therapist asking for it. Um, and then a court-ordered judge would have to determine whether or not you would be compelled to testify or submit documentation. If a court order is not issued, then there's no other response needed from you. If a court order is ordered, there's a lot of order in this slide. You have three options. You can request a meeting in camera behind closed doors, so the provider would meet with the judge alone and explain why they do not want to testify. The one time I've ever gone to court, I did this, and my testimony was thrown out because I was subpoenaed by the opposing side's judge. It was a divorce case, and the husband knew that I was seeing his wife, so they got a subpoena from my client. The subpoena was from the husband who was suing me because they wanted me to testify that she was a bad mom, even though the ROI didn't come from her. So I appealed the subpoena. They did a court order. I requested an on-camera meeting. I went to talk to the judge, explained the situation, and my testimony was thrown out. What I did find online, though, is that this doesn't happen very often anymore. This was far more common in the 80s and 90s. It is still done. It's just rarely accepted. You can respond to the court order and release the records or testify. The APA does highly recommend that you always hire your own counsel for any depositions or examination. In fact, they state you should have your lawyer present with you, even though you're not the one being sued or brought to court. Lastly, you can refuse the court order and be held in contempt of court and arrested. And I actually read a couple of really interesting cases where therapists still chose to do this to try to protect their clients' confidentiality. In a very famous case in the early 90s in Cincinnati, a therapist had been held in prison for over 90 days until finally the court-ordered judge allowed the person to leave. But they did so because they believed that they were protecting their client's confidentiality. It'll be easier to see this once I sent the PowerPoint, but for more grounds on how to oppose records releases or testimony, either through lawyer or other government agencies, there's a whole CE course you can look at, but they also have a sort of written abstract of about 20 different ways that you can use legal statutes and APA ethics to avoid releasing records. So I highly recommend that you check this out. It's very helpful. So hopefully that was sufficient and only moderately overwhelming. Any questions, comments, concerns, nightmares? Or any cases that you have going on right now, or other questions I didn't address that you maybe submitted in the survey?
I have a client actually going through this right now, and they just had a few months ago, had their first application like denied, and they're in the appealing process. Mm-hmm. And I was curious, is the reconsideration appeal different than the hearing appeal? Like, those are like steps 2 and 3 essentially?
Yeah, so the reconsideration process is whether or not the Office of Disability Determination will even hear the second hearing. So once you get through reconsideration, it's approved, and then the Office of Disability Determination hands it off to a different organization that does the hearing, and then they have to approve of the hearing. My understanding is that second hearing or approval hearing is never really denied.
Okay.
Because the reconsideration was approved. What they mean by approved in the second hearing is that we approved to meet with you in 6 months on this date. So it's really just establishing a timeline because they very rarely disagree with disability determination.
Okay, gotcha. I think that's where my client is at right now, is waiting for to have the hearing scheduled. And that's been they've been waiting, I think, getting close to a year, but yeah.
Yeah, it's a painful process, and it's for anybody who's worked with veterans and worked with people who are trying to get disability through the VA, it's even harder and an even longer process. Their reconsideration process is that you get brought in for a meeting, and because I worked in Norfolk, about half my clientele were veterans or active duty. The reconsideration process was you standing in front of a panel of people, and you just try to get to the point where they say, okay, we approve of you for a reconsideration, and then you have to go to a hearing. So that's even worse. Here, my understanding from what I read online, and I didn't ask the Disability Determination Office but my understanding is that if you get approved for reconsideration, you will have the other hearing. It just might be really long further down the line.
Okay, I have a question, but it might be dumb. How does
There's no
FMLA,
dumb questions.
how exactly does FMLA fit into this? I mean, it's a totally separate process, right? But I've been presented with forms that seem a little it's like, fill out this form where I would, I am asked how frequently my client can work, in what capacity, are there any exceptions, those kind of forms. So I don't know if there's anything to say about that might be useful.
I don't have an answer because FMLA did not come across anywhere in any of my research or readings. I think it's a completely separate from the Office of Social Security. I am aware of people who've taken FMLA who then have used the rest of their sick time to extend their leave, but I don't think that's disability. So I can look into that and try to get you an answer, but FMLA didn't come across anywhere.
Thank you.
You're welcome.
It is interesting, though, sort of the difference in the FMLA form, like very explicitly asks you to essentially make a determination about this person's ability to do their job. And sometimes it feels like, is this appropriate for me to be doing necessarily? It is a very different animal.
I've only done FMLA paperwork once, which I don't know why. The bulk of my career has been disability paperwork, but even in the FMLA form, I just said I'm not in a place to do this. I cannot, in good practice or ethics, evaluate the person that I have a clinical relationship with, and they just assigned a different evaluator. That's what I was told anyway after the fact. Because the APA does make that distinction between an evaluating psychologist and a clinical psychologist. So if you are operating in a clinical capacity, you do have the right to refuse any evaluative process.
That's cool.
Yeah, Michael, I really appreciated your distinction of that for Social Security, because hey, the stakes are usually so much higher, right? It's like somebody could be on disability for years and years, forever, versus FMLA usually is short term. But it is funny because I think in FMLA they see you as both like historian and evaluator, which is a role we've never been talking about training. Like I've never been trained how much time is a reasonable amount of time for someone to miss from work or whatever. So I find myself often just having to like talk it through with the client and say like, how much time are you usually absent from work? Does that feel like useful to have the days off versus does that feel like actually, a loss of like social rhythms and things that's actually really helpful for you? So it's very messy. I don't like FMLA paperwork for that reason.
I had a client who just went on FMLA, but I didn't fill out any of the paperwork, and they asked if I was willing to, and I said, of course, but there's like going to be sections that I don't really respond to. And they said, what do you recommend? I said, you have a psychiatrist. Have your psychiatrist fill out the forms. And what I found so interesting is that in the past, when I filled out those paperworks, I filled out like 5 to 10 page long reports, and then the psychiatrist sends in one letter with like 4 sentences saying they've been diagnosed with this and they're on these prescriptions, and then they got approved. And so they got a 2 months of FMLA because of one letter from a psychiatrist. And I think that's like inherent bias towards MDs, honestly. But
well, the ones I've done, they're like a standardized form. Like it is just fill in the blank. Like you don't write a letter or a separate narrative. You answer the very specific questions on the form.
I always attach. I can never fill the forms are too small. But yeah, you're not supposed to do that. You are supposed to just fill out the form. Don't do what I do.
I have a question about short-term disability because you mentioned, I think more from the perspective of like employers or our roles as psychologists, but I suppose from a client's perspective occasionally as well. So what did you learn about Maine? I recently met a group practice owner